are available, my lord, in the judicial system.
Yes.
But if your lordships may kindly take the writ petition which starts at page 36. But I am starting from internal page 28 of the writ petition after the cause title.
Appellant is board and its chairman.
देखिए अच्छे थे
Its functionaries are there. পর্যন্ত। তুমি move it, leader box. Equivalent.
board president and secretary.
All right. Yes.
But unsuccessful candidates are before the High Court in the writ jurisdiction. Please take me lord page paragraph number 3 onwards. Your petitioner states that on 19/10/2012, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary schools. It is needless to say that there were huge irregularities in TET 2012 and several cases were filed. In spite of irregularity and illegality, 18,000 teachers were recruited, and Government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examination, and in that case they shall be exempted from paying any fees for the examination. The petitioner states that on 12/11/2014, NCTE published a notification dated number so and so, and in that notification, qualification and other procedures for recruitment were prescribed. Para 5, your petitioner states that on 9/4/2015, Ministry of Human Resource Development published a notification under so and so dated 9th of April 2015, extending some relaxation to the state of West Bengal till 31st of March 2016. Your petitioner states that on 14/7/2015, Government of West Bengal published a notification framing certain rules disclosing about the requisite qualification, etc. Then 7 is, your petitioner states that on 11/10/2015, TET 14 examination held in West Bengal, where huge number of students appeared. It is needless to say that on the date of examination, the notification issued by the MHRD was in force, and all the students who passed and or qualified in TET 14 should get benefit of the notification of 9/4/2015. Your petitioner states that on 2/3/2016, the recruitment rules of 2016 was notified, and Rule 6 of the notification speaks about qualification of persons who are seeking and or eligible for appointment. In clause 6, subclause 3, some specific guidelines are there for non-trained teachers. It is needless to say that all TET 2014 candidates are entitled to get benefit of this instant rules and the notification issued by MHRD. Your petitioner states that on 14/9/2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26/9/2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. Or in other words, Milord, first the trained candidates will be appointed, and for the rest of the vacancies, untrained candidates. That was the relaxation. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have the training will be considered too. The notification proves that the board decided to give something of the relaxation benefits of relaxation to all TET 2014 qualified candidates. Your petitioner states that after the notification, the procedure was started for appointment from October to December 2016. The interview and verification started on 31st of January 2017. Allegedly, the merit was declared, but there was no panel, there was no merit list, there was no category-wise, merit-wise, no division of numbers, and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 31/2017, list of trained candidates were published. On 4/2/2017, list of non-trained candidates other than the Bengali medium was published. And on 8/2/2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 14 were appointed through the first list, and after completion of the same, as per notification of 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Your petitioners state that on so-and-so date, notices were published for recruitment as assistant teachers in primary schools from TET 2014. The board has appointed non-trained teachers after 2016 even, and intentionally ignored the petitioners by giving excuse of notification of MHRD by way of so-and-so dated 9th of April 2015. Thousands of non-trained students were appointed, and petitioners, those similarly placed, were ignored. But this is the only case. Petitioners who were similarly placed were ignored.
They were also non-trained.
Untrained candidates or non-trained candidates. Untrained. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by the NCTE is applicable to all in any TET 2014 candidates who qualified in the examination.
So they board appointed untrained candidates. Petitioner says that I am also an untrained candidate, but you have not included
me, or you have given deprived me and given appointments to other non-trained candidates. But this is the short case. Now this has been stretched to I should say, my lord, and illogically extended, my lord, adjudication of the matter. Your petitioners state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Board of Primary Education published one notification of recruitment of 16,500 primary teachers. This is the subsequent recruitment process. I don't think I need to trouble your lordship with this part. Then 13 Millard, they give examples of 4 persons who were allegedly non-empaneled, but they got appointment. And then Millard, kindly take Millard, paragraph 14. Your petitioner states that at present there is more than 1 lakh vacancy in the education department. Since 2011, several examinations were conducted to fill up the vacancies in the school, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected. These are all prejudicial facts. Then, Millard, paragraph 15 is where one honorable member of the parliament had made certain comments. The others are MLAs who have made certain comments. Then paragraph 16, biggest scam, TET 14 is a biggest scam. Para 17 again, TET 14 is a biggest scam, and 14 to 20 lakh rupees were exchanged. Then kindly take Millard, para 18.
So you were unsuccessful in TET?
The writ petitioners. No, they were successful in TET, but as your lordships know, Millard, TET is a qualification for applying as for recruitment for the
so they passed TET.
Yes, so far as passing of the TET examination is concerned, there is no dispute.
Now they are saying that TET
that they have been, yes, what their case is that they also fall within the untrained or non-trained category.
Who were not successful in TET?
No. Everybody are successful, because unless somebody is a TET qualified, like me, I can apply for enrollment only if I pass the LLB degree course, or I can apply for judicial service provided I pass the LLB course. So therefore, TET is like a qualification, isn't one of the eligibility criteria. Your petitioner states that the board has started different cases before this court, that 42,897 candidates were selected. till date, but no merit list of the candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, and a reservation category wise list should be published. Candidates were informed through SMS, and no merit list of so and so candidates were published, and it proves the mischief in the recruitment process. If the process was free from all corruption, then there ought to have been a transparent merit list of so and so. The process was not completed in February 2017, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers, but these are all submissions without any proof whatsoever, any evidence whatsoever. Be that as it may, I will deal with each of the allegations. Were appointed as primary teachers by the board, and in spite of specific steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have given suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified candidates were not issued to them, and even today they were fighting for that. There is no delay in filing the PIL, etc. I do not know from where they have copied this, but this is there. Then para 19. The petitioners state that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, etc. I don't think that these are that important. Then para 21, 22, they all speak of corruption everywhere, and then are the grounds. Now, what is very, very important is the prayer and the date of affirmation of the written.
So, you tell us what was their pleading based, what were the arguments they were advancing?
Milord, I can speak of the argument provided, Milord, the proceeding was confined to or limited to the pleadings, and Milord, the affidavits in opposition and the replies.
According to you,
yes, there was no argument.
What were the contentious issues?
Milord, there were no argument. Now, Milord, I'll place the judgment. There was no argument.
No,
but I would start from placing judgments before this court, that what is meant by a judgment and what should be the characteristic of a judgment.
No, according to you, Mr. Dotto, on the pleadings, what were the infirmities they pointed out?
Milord,
one was untrained, similarly situated,
but this is the only part.
No merit list was published.
No merit list, Milord, that Milord, I'll satisfy, Milord. Yes.
Third is there are discrimination among certain persons.
3 or 4 examples were given. 3 or 4 examples given.
So primarily it is thing that I am unsuccessful. Yes. So you turn down the entire.
No. That was not the prayer. That was not the prayer. Now please have a look to the prayer. But I will take your lordship, Milord, from the very first order which was passed in this writ petition. But this matter has, Milord, very many facets for your lordship to decide, in addition to the merits of the matter. And
it has not come up in appeal against.
No, because the entire recruitment process is conducted by the board.
TET is also
conducted by the board.
Yes, show us what you are showing.
Yes, now kindly have a look to the prayers. 47. At page 47. Prayer A is Rule 26 dispensation. Prayer B. A writ of in the nature of mandamus be issued directing the respondent authorities as follows: to act in accordance with law, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from TET 2014, including the date of recruitment. To direct the authorities to treat the petitioner equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by MHRD on so and so. To recruit the petitioner by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd of March 2016 and appointment notification dated so and so. Direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment to protect the records, etc. Statutory right. And my lord, in this writ petition, my lord, 36,000 appointment has been set aside without any prayer.
Yes.
The date of affirmation is very important, 12th of September 2022. In respect of a recruitment drive in the year 2016.
When was the last appointment made?
Last upon 20.
February 2017. Apart from
Please ask your junior to.
Yes, 2017 February. But in addition to that, Miller, there are certain court orders. Under court orders also appointment made, but
Subsequent to 17.
subsequent to 17, but these are all under court orders. But so far as the board is concerned, in the recruitment process, the last appointment was made in February 2017.
recommendation.
Or recommendation.
Yes.
Now, Miller, I need to, Miller, take your lordship, Miller, through the orders passed by the learned single judge from the day of entertaining the writ petition. But judgment period under appeal, my lord, I'll come later on.
Yes.
My lord, your lordships may kindly take me the third paper book, page 418. আচ্ছা আমাকে পেজ নাম্বার গুলো বলে দিবি তাহলে।
Four hundred and
6-2-22 কত তারিখ? এই কত পাতা? 6-2-22
418.
6-2-22
415 it starts.
415.
তুই আমাকে 6-12-2022 পাতাটা বল। Please take me the page number 415 first. This is dated 6th of December 2022.
Yes.
The petitioners appeared in the 2016 recruitment process. All of them are TET qualified, as has been submitted from the bar and pleaded in the writ petition application. The petitioners came before this court after the documents and marks produced before the division bench, headed by the Honorable the Chief Justice, in one of the matter which was first moved before me, and I adjourned the matter, seeing the nature and character of the same as a PIL, and sent it before the Honorable the Chief Justice.
This is not the writ petition against which this appeal is coming.
Yes, this is the writ petition.
Two double
No, the one which is referred is another. Yes.
Then why we are going into?
No, this order is passed in this writ petition. 6th of February, December 2022, this order is in this writ petition.
This is this appeal is arising out of 21187.
Miller, these are.
What is your writ petition number? This
WP,
21187.
WPA 21187 of 2022.
So this is your their writ petition.
Their writ petition.
This is the first order in that.
Yes, it's in fact the third order, but the previous orders are not not that important.
Yes.
Then, Miller, the next paragraph is the petitioner has come to learn that in 2016 recruitment test, a large number of untrained candidates were given recommendations and appointments by the West Bengal Board of so-and-so and the respective councils. The petitioners given said a large number of candidates were appointed who got marks below the petitioners. The petitioners got this information from the learned advocates who inspected the concerned list. The petitioners submit that despite their marks being higher than the untrained candidates of 2016 and were called in interview and aptitude test, none of them were called in the interview. Learned advocate for the West Bengal Board of so-and-so has drawn my attention to the prayers and have stated that in one prayer the petitioner has prayed for publication of some information which are already in public domain. But I am told by the petitioners that the petitioners' breakup of marks are not in the public domain, as the candidates who were recommended, only their marks have been uploaded. Learned advocate for the board has also raised the question as to whether the petitioners applied for the recruitment test of 2016 and whether they were called for interview at all. After considering the submissions of the parties, I direct the petitioners to disclose the application filed by the petitioner and call letters for interview of the petitioners by filing supplementary affidavit. The petitioners shall also disclose the documents as to their training qualification, if any, taken by them. The training qualification documents, if any, shall also be disclosed. Or Miller, the court is inviting documents from the petitioners. Why this is important, Miller, as I progress, your lordship would find. Kindly take the next order of 20th of December 2022
418.
at 418.
Yes.
The case of the petitioner in short is that though the petitioners got higher marks before addition of marks against interview and aptitude test, comparing to some of the candidates who have been given the appointments against 2016 recruitment process ever after adding their marks for personality test and aptitude test, they have not been given appointment. Please mark this last sentence of the court. The petitioner's case is that interview was also held, aptitude test was also taken. But why this is important, I'll come later on, because the judgment proceeds on the basis that no aptitude test was taken and the honorable judge had called witness, cross-examined the witnesses. A complete unknown procedure. Allegedly in exercise of power under section 165 of the Evidence Act. But please mark this sentence that it is the case of the petitioners that adding the interview marks and aptitude test marks given to them, they were not given appointment. This is the recorded case. Though, my lord, it's not there in the writ petition, I had placed the entire writ petition before your lordships. They have come before this court as have been submitted after
No,
taking
just
inspection.
one
I'm
more.
sorry.
Though the petitioners got higher marks, this is higher marks on which evaluation? This is prior to the interview.
No. But after completion of the entire process, according
Said that though the petitioners got
higher
higher
marks,
marks before addition of
of
marks
marks,
before interview and written.
yes.
So prior to this interview and aptitude test, there was any further rider?
Miller, Miller,
only
as your lordships know, Miller, there are certain marks for academic qualification which is added. These are those marks which, upon addition,
Addition of academic qualification, they got higher
marks,
marks.
this is their case. But what is very important over here is that finally, Miller, the Honorable Court has not gone into this. The judgment which is under appeal before your lordships proceeds completely on the basis that no aptitude test was taken, therefore entire process is bad. I'll come to that, but this is very important. How, my lord, the stand is getting changed from time to time. Therefore, my lord, the first positive assertion is recorded in the order of 20th of December 2022. They have come before this court as has been submitted after taking inspection from the records produced before the Honorable Chief Justice's court in a public interest litigation, and they have also got some inputs from the publication of marks of the M-panel candidates. In respect of WPS 1, so the present one, the petitioners have prepared a tabular chart of 139 candidates, and the petitioners submit that all those 139 candidates have got higher marks than the last employed candidates, but they have not been given appointment. Pausing here for a moment, this point also I will be taking that these tabular statements, Millard, are not pleadings. There has been no amendment of the writ petition.
Yes.
Mr. Ratul Bishwas, learned advocate for the board, prays for some time to check the marks of so-and-so, making appropriate submission so-and-so. For this purpose, I fix so-and-so. Along with the matter, such and such are being moved, I direct so-and-so in for application to supply similar tabular sheets to Mr. Bishwas, and Mr. Bishwas will come after verifying. Mr. Bishwas is also directed to come with particulars of the tabular form, etc., etc. Then please take me, Lord, the next order. This is very important for me. 17th of January 2023. Kindly similar the turn of events from here. But as I said, Millard, your lordships,
Yes.
but I would invite your lordships not to only confine to the merits of the judgment. The procedure which has been adopted in the adjudication of the instant writ petition is very important, Millard. Otherwise, Millard, for the future, Millard, this will remain in the records of the Calcutta High Court.
Hmm. Page, which
Millard,
page?
page টা বলতো?
Page 421.
Page 421, 17th of January 2023.
Yes.
In course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks are there also for interview. Completely contrary to the previous days, Millard recording. Please come back to Millard, the previous order.
Both were held.
Both were held, marks were added, and thereafter, people who got lesser marks were appointed, petitioners were deprived.
Hearing they say that there was no interview.
No aptitude test. Interview was taken, but there was no aptitude test. Though in aptitude test, there are 5 marks. Or Millard, under the rules, Millard, for aptitude test, Millard, 5 marks are allotted. Interview 5 marks, aptitude test 5 marks. So a completely contrary case. I do not know who has made out, but it is recorded. Now kindly see, Millard, the Honorable Court takes upon itself the power under section 165 of the Evidence Act. As a large number of petitioners were present in the courtroom, this is the reason. So many petitioners are before your lordships, therefore, Millard, the law is going to change. As a large number of petitioners were present in the courtroom, I decided to exercise my power under section 185 of the Indian and I asked some questions after administering oath to 7 of such candidates being petitioner numbers, etc.
Yes.
Millard, section 165, as your lordships know, Millard, this is exercised by the court or the judge in course of trial to elicit some points which may have been left out by the prosecutor or
Yes.
the cross-examiner, or to get some clarifications if required. Or if the court finds that the cross-examiner is not putting the right questions.
Mm.
Now the court, Millard, takes upon itself the burden, in my very respectful submission, a misconceived burden. Kindly pardon me, Millard, for adding this expression of exercise of powers under section 165.
Yes.
First, Millard, the judge holds the trial. Then the trial is over in the next sentence. Please have a look to that.
Yes.
The next page, Miller. From their evidence, I am satisfied that there was no aptitude test for the said petitioners. Trial over. Finding given.
Yes.
Learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. In such circumstances, now Milord, the court is eliciting, Milord, documents, evidence. In such circumstances, I direct the president of the board to file one affidavit by 7 days from the date disclosing whether there was any aptitude test in 2016 selection process and what is the method the board is following this year to take the aptitude test of the candidates. It goes, this year means, Milord, it goes beyond the writ petition. This was 2023. When, Milord, the 2022 recruitment process was ongoing.
No, after this 165 episode, your advocate was asked that you submit the documents. Writ court cannot call for documents, Mr. Doctor.
Milord, definitely. The writ court has the power of certiorari. The writ court can definitely call for documents, but not allegedly after exercising power under 165. Milord, your lordships have the power. In a case, Milord, your lordship finds that there is some disputed questions of fact which can be resolved by way of production of documents, because disputed questions of facts are not always barred for adjudication by the writ court. No quarrel on that issue. But situation under which, Milord, the writ court exercises its powers in adjudicating disputed questions of facts are where your lordships find that from the documents on record, a disputed question can be adjudicated. And for that purpose, Milord, one or two documents here and there missing, your lordships may call for that.
You did not challenge these orders at that stage.
No, these were not challenged.
Yes, next, what you want to say?
Yes. Then, Milord, the president of the board is directed to, Milord, file an affidavit. That was filed. I'll take your lordship, Milord, in the pleading sequence. Now, kindly take note the next order dated 24th of January 2023.
Yes.
I directed the petitioners that at least 2 candidates from each district are to be present before this court, as the court wants to know from them about the interview and the aptitude test taken by the board in 2016 selection process. Milord, parties call witnesses.
Yes.
Both under the Civil Procedure Code as well as, Milord, the Evidence Act, it is the party to a proceeding who calls their witnesses. Court is not powerless. Court can also call, Milord, a stranger to come and depose. But ordinarily, it is the parties who are to produce their witness
Yes.
in a trial. Of course, Milord, I need not, Milord, dilate before your lordship that these trials are not held in the writ jurisdiction. But kindly consider, Milord, how the case proceeded. So I directed the petitioners. Or, Milord, my submission is the court calls witnesses over here.
Mr. Dotto, this has merged with the final order.
This is, Milord, this is why this is essential. Why I am troubling your lordship with all this is that finally, Milord, my point would be predisposition of mind of the court. Now, in order to prove this predisposition, Milord, how the case was conducted is required to be demonstrated before the court.
Yes. Which page next?
The 24th of January order, kindly take the last two lines. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power. Under section 165 of the Indian Evidence, as I want to take evidence of the candidates from each district. A procedure completely unknown.
Hmm.
My lord, for a moment, my lord, my submission is not that the writ court cannot take evidence. My lord, there are exceptional situations where the writ court can take evidence. This is not one of those where the court elicits documents, the court elicits, my lord, evidence for the petitioners. The court is collecting materials for the petitioners. I'll gradually, my lord, I'll demonstrate before this court. That is, my lord, a procedure which is not permitted by law. But my lord, writ proceedings are, my lord, Order 19 proceedings. They are adjudicated based on the affidavits that are filed before the court, and whatever are annexed to those affidavits and the writ petition.
Allegation was a scam to whatever may be the procedure. The court, Mr. Dotto, cannot go to the nitty-gritties.
Now, what
How
was the
you have-
final GSS? But my lord,
We understand your argument. Now you tell us that whether it is absolutely you are showing, you said so, that predisposition of the court's mind.
yes,
That these were the rudiments on the basis of which the court has come.
yes.
Yes. Yes. Then
Then, my lord, now I start, etc. Some names from each district have been intimated to me by the learned advocate for the petitioners who were candidates in the 2016 recruitment process and appeared before the interview board, but all of them were unsuccessful. Though the name of one Shankar Thapa representing Uttar Dinajpur was mentioned in the list handed over to me by the petitioners, Mr. Thapa is not present, and I have taken evidence of 19 candidates exercising my power under section 165. I have received the affidavit as was directed by this court on 17/1/23, affirmed by the president of the board, which is kept on record. The instruction of the board under memo dated 11/1/23 was shown to the court and handed over to the learned advocate for the petitioners by the board. The petitioners have come up with one exception considering the said memo, that is the instruction affirmed on so and so, which is also kept on record. The respondent board wants to deal with the said exception. The board wants to file one affidavit in opposition to the writ application for which no prayer was made and therefore no direction was given. Now, at this stage, when the evidence of a large number of petitioners have been taken, which are throwing light upon one of the allegations of the petitioner, I will not allow filing any affidavit in opposition in this matter by the board. I direct, where another affidavit is being directed, the president of the board to file one affidavit further explaining what is an aptitude test. And this explanation is to be given after consulting the experts in the teachers training field. And the names of the experts are also to be given to the court in a sealed cover, and it will not be disclosed to the petitioners. The president of the board is also directed to produce one list in a sealed cover, which will not be given to the petitioners, which will contain a list of names of the interviewers and their designation in respect of the interviews of the candidates whose evidence has been taken by this court. This list shall remain a secret list, so and so. Direction given to the petitioner, etc. Then, my lord, your lordship may take, my lord, the next one where, my lord, seal cover proceed. I mean, everything was given in seal cover. That is where that is recorded here on the 6th order of 6th of February 23. Page cover at page 427.
yes.
Please take note the second paragraph. First paragraph is the affidavit was filed by president as directed. Second paragraph is the letters issued by the board to different experts as to aptitude test were in a seal cover which has been opened in court, and those letters were kept inside again after perusal of the same by this court, and that envelope should be sealed again. Another sealed envelope containing list of persons who took interview of different districts, namely districts of so and so, have been produced, and those lists are contained in small sealed envelope which are kept inside the big sealed envelope. Out of those interviewers, the envelopes in respect of the district of Hooghly, Howrah, etc., has been opened and kept in a separate pile. The other small envelopes in respect of other districts have not been opened, and they are kept in a big envelope, and that big envelope is to be sealed again. Out of the interviewers of the following districts, namely so and so, I need to know some facts about the interview and aptitude test, and whom I call for appearing before this court on 21st of February. So now,
Yes.
now my lord, interviewers are being called, and I call for and whom I call for appearing before this court on 21st February at 2 p.m. and the expenses of their journey, etc., I don't want to saddle. The amount to be paid is so and so. I do not call all the persons named. For the district of Hooghly, I call persons named in serial number so and so. Then other districts so and so. On 21st February 23, this proceeding of asking some questions to the interviewers would be done in camera, and their reply to the questions would be recorded. List this matter on so and so, the board is directed to so and so. Now, please take, without skipping over one order, please take the order of at page 432. This is also of 6th of February.
Hmm.
Where on the same day, two orders were passed. One in the first session, the other in the second session. The second session order is at page 432.
432.
Yes, ma'am.
No, yes, yes.
But this is in the second half. Pursuant to the order passed
Date returnable was 21st February in the earlier
earlier one, but this was
taken in the after.
after, yes. Pursuant to the order passed on 6th of February, evidence of the following named teachers who took interview of some candidates in 2016 recruitment process for so and so, conducted by so and so of the district of so and so, were taken up. The real question was,
No, were they those interviewers in paragraph 7 of the earlier order?
yes, they are the interviewers who were called Millard.
By the 6th of February order.
Yes,
So they were present in court.
appears to be so. Thank you.
So thereafter they were interviewed. Very good. Now,
কোনটা এটা 21st হবে
21st February.
ডেটটা wrong
21st August. Yes, that is what is written.
হ্যাঁ ওটা কত হবে এটা 21 হবে
This is 21st February.
আচ্ছা
Oh, not on the same date.
very well, I stand corrected. Huh? But I am told in the website, ঠিক আছে বলছে যখন
Very good. This is 21st February.
February. Yes, when my learned friend is saying so, I will not contradict.